Hi friends, good morning. Welcome to Annamaya IAS Academy. This is Dr. Harinath Reddy. Today in this particular video, we will try to discuss one more important topic related to Indian judiciary, that is judicial activism. On judicial activism, several questions have come in PSAR optional, PUBAD optional, law optional, GS paper 2 of UPSC mains and also AP group 1 mains and TGPSC group 1 mains exam. So we'll try to discuss this topic at a greater length. We all know that Indian constitution is a written constitution. And in a constitution which is written, there is a supremacy of the constitution. So in India, to protect the supremacy of the constitution, we have an independent judiciary with the power of judicial review. We have the Supreme Court of India at the apex. So the Indian Supreme Court is the final protector and interpreter of the Indian constitution. High courts, though high courts also have a role, but the final responsibility is with the Supreme Court. So the Supreme Court, by using its power of interpretation, will protect the Constitution of India. That's why the Supreme Court is called the guardian of the Indian Constitution. So as part of its role as the guardian of the Indian Constitution, the Supreme Court and the High Courts in this country have exercised an activist role on their part. Then what is judicial activism? So judicial activism refers to the active role played by the higher courts in this country, that is the Supreme Court and High Court, in upholding the Constitution and in protecting the fundamental rights and also trying to fill the gaps created by the inaction on the part of the executive and the legislative branches. But if you remember, in the pre-emergency period before 1975, the courts in India, they were following a philosophy called judicial restraint. Judicial restraint. In other words, so the interpretations given by the higher courts was narrow to the fundamental rights and other rights under the Indian Constitution. But post-emergency, we know that there was one important case called ADM Jabalpur case. ADM Jabalpur case. So ADM Jabalpur versus Shivakanta Shukla case. This is during the emergency era between 1975 and 1977 when Indira Gandhi has declared national emergency on the ground of internal disturbances. Several individuals and citizens, they have gone before the High Court when their fundamental right to life and personal liberty was suspended through a presidential order. Several High Courts said that fundamental right to life and personal liberty is a very important fundamental right and it cannot be suspended even when national emergency is in operation. That's the stand taken by majority of the High Courts. But when the matter went to the Supreme Court has upheld the presidential order suspending the fundamental right to life and personal liberty. So this was an important judgment because of which the Indian Supreme Court became quite unpopular. So this judgment was said to be the dark period in the history of the Indian Supreme Court. So the Indian Supreme Court during internal emergency stood with the side of the government and did not take the side of the people. So this judgment was criticized as one of the blunders of Himalayan proportions by the Supreme Court. So post-emergency, the Supreme Court started actively reinterpreting the provisions of the Indian Constitution. One example for that is, we have in 1982, which is also called first judge case. In this case, in 1982, SP Gupta versus Union of India. This is the name of the case. SP Gupta versus Union of India. This is the case in which the Supreme Court has come up with something called public interest litigation. So in India, there is a principle, a legal principle, which is called principle of locus standing. Principle of locus standing. So this principle says only the aggrieved citizen can go before the High Court or the Supreme Court for the enforcement of his fundamental rights. The principle of locus standi says if my fundamental rights are violated, I am the aggrieved citizen, I can go before the High Court or the Supreme Court. But on behalf of me, another citizen, concerned citizen, cannot go before the High Court or Supreme Court. So this principle of locus standi was diluted. This was diluted in this case, in SP Gupta versus Union of India 1982 case. The Supreme Court has diluted the principle of locus standi, which means on behalf of any section of citizenry whose rights are being violated, any public spirited individual, any public spirited organization can file a writ petition before the High Court or the Supreme Court for enforcing their fundamental rights. This concept is called the concept of public interest litigation. And there were two important judges who were responsible for evaluating of this concept of public interest litigation, P.N. Bhagavati and V.R. Krishna Iyer. So because of the evolution of the concept of public interest litigation, even a postcard or even a news item in the newspaper is considered as a petition to be taken up before the High Court or Supreme Court for protecting the rights of the disadvantaged social groups. So by increasingly using the public interest litigation powers of the High Courts and Supreme Courts, the rights of the prisoners, the rights of the under trial prisoners, the rights of the disadvantaged social groups, and also environment were all protected by using public interest litigation. So this is the beginning of judicial activism in the post-emergency period, And again there was one important case, Menaka Gandhi versus Union of India, 1978. So in this case, the Supreme Court has given a broader interpretation for the fundamental rights guaranteed under the Indian Constitution in Part 3. So the Constitution of India, which came into force on 26th January 1950, it provided for procedure established by law. Procedure established by law. This is borrowed from Japanese Constitution. But American Constitution, it is based on due process of law. Due process of law. So in 1978, in Menaka Gandhi versus Union of India, the Indian Supreme Court has borrowed the concept of due process of law, which is there in American Constitution, into the Indian context. What is the consequence of that? Under due process of law, the courts will have wider powers. Under procedure established by law, the courts have limited powers. So under procedure established by law, if you want to deprive any person of his personal liberty, there shall be a law in place. It can be done only with the authority of the law. That is the first condition. The second condition, such law should be made by a competent legislature. Second requirement. Third requirement, such law shall be made after following the procedure prescribed in the Constitution. If all these three conditions are met, then deprivation of personal liberty is upheld by the courts under procedure established by law. But under due process of law, in addition to these three, there shall be a law in place, that is, which means the executive cannot do that. The executive can do this only with the authority of law, and that law should be made by a competent legislature by following the procedure laid down in the Constitution. So under due process of law, in addition to these three conditions, any law made by the parliament or state legislature shall uphold the principles of natural justice, which means the laws made by parliament and state legislature, if they are unfair, unreasonable and unjust, they can be struck down as invalid. So this has enhanced the powers of the Supreme Court and the High Court. So the due process of law, which was brought into India in Menaka Gandhi case, and the concept of public interest litigation, they have vastly expanded the powers of the High Court and Supreme Court, and that led to the activist role of the High Court and Supreme Court, and it has really played a very important role. So let us see what is the positive impact of judicial activism. So because of the activist role played by judiciary, it led to greater accountability and transparency in the working of the executive branch. So if you remember the 2G scam, which was exposed through the action of judicial activism, it led to better allocation of transparent allocation of 2G spectrum, transparent allocation of, there was one more scam called coal scam. So even this went before the Supreme Court, that led to transparent allocation of coal blocks. So one positive outcome of judicial activism is greater transparency and accountability of the executive branch. Then the other one is protecting the fundamental rights. It's not only protecting the fundamental rights, expanding the fundamental rights. If you remember, in the Constitution of India, in Part 3, there is one fundamental right guaranteed by Article 21, fundamental right to life and personal liberty. The scope of this fundamental right to life and personal liberty was greatly expanded by the Indian Supreme Court through its creative interpretation. The Supreme Court said a right to life includes right to health, right to education, right to livelihood, a right to healthy environment, right to free legal aid, right to education, right to privacy. So this is the effect of judicial activism. So the Indian Supreme Court has widely expanded the meaning of right to life under Article 21. It has not only protected the fundamental rights, it has also expanded the meaning of the fundamental rights. The second advantage. The third one, in a number of public interest litigation cases which went before the Supreme Court took that as an opportunity to give important judgment for protecting the natural environment. See, protecting the natural environment, it is not only a duty of the citizen under Part 4A, it is also the duty of the state under Part 4